Good day, everyone. This is Crime Talk. My name is Scott Reich, and this is our summary of the week's top stories, all conveniently located in one location. We hope you enjoy it, and we'll see you next time.
Hi, lawyer.
There's been some significant rulings as it relates to the Chad Daybell case. Now, the first one I want to talk about, and frankly is not surprising, is the motion to reconsider the change of venue that was filed by the prosecution. Now, just a quick procedural background for those who aren't familiar with the case. Back on May 24th of 2021, a Fremont County jury returned an indictment charging Chad Daybell and his co-conspirator, Lori Vallow, with multiple crimes, including multiple counts of conspiracy to commit the crimes of first-degree murder. Daybell was also charged with several counts of first-degree murder and insurance fraud. Then, on July 21st of 2021, Chad Daybell filed a motion requesting a change of venue. The state objected to that request, and on September 29th, 2021, that was filed. And then on October 5th, the court heard arguments and received evidence on the motion, and the court entered an order granting the defendant's motion for a change of venue. And that's kind of significant. That's where we were moving from Fremont County up to Ada County. And the court goes through kind of legal standards analysis, but I think the analysis that the court put in its motion is probably by far the best explanation as to why the court did it. So, as a prefatory comment, the court will clarify the issue at bar. Defendant argues it is procedurally inappropriate and flawed for the state to request a change of venue. However, the record reflects the correct posture of the pending motion. The state is asking the court to reconsider the decision to transfer trial from Fremont County to Ada County and return the trial proceedings to Fremont County. Given that procedural posture, the court finds that the state's motion is appropriately considered and will be determined on the merits over the procedural objections of the defense. From the outset, this case has garnered significant media attention. Daybell's alleged co-conspirators was tried and convicted on all charges brought by the state against her. Now, while her trial was not televised, daily release of the audio was repackaged and broadcast by various media entities. Therefore, the analysis before the court is under Criminal Rule 21, whether the court is satisfied that a fair and impartial trial cannot be had in Ada County, where the case is currently set, to reconsider bringing it trial back to Fremont County. The state argues the trial of Lori Vallow conducted in Ada County, Fremont County case number 22-21-1624, was heavily covered across various media platforms in Boise and Ada County, and that the more recent media saturation there now poses the risk that the jury pool for Daybell's trial in that venue is likely tainted. The state suggests that given the trial publicity in Ada County earlier this year, Fremont County may now be a better venue for locating a fair and impartial jury. To support this argument, the state referenced the media coverage in Ada County, but did not provide further empirical evidence to demonstrate that media coverage during the trial of Lori Vallow's trial had been so saturated the prospective jurors in Ada County that it was unlikely to impanel a fair and impartial jury. In fact, no additional evidence has been presented in support of the motion, which rests solely on argument. While the court may draw its own reasonable inferences based on the experience of residing in Boise during the trial earlier this year, such inferences are not as compelling as empirical evidence that could have been submitted in support of the state's motion. Neither has the state demonstrated how that same extensive coverage has not also continued to inform and interest the prospective jurors in Fremont County or any neighboring county in the 7th Judicial District. As the court mentioned at the hearing, it is likely that the sentence of Lori Vallow Daybell on July 31st, 2023 was the apex of the media coverage and public interest, and that the hearing occurred in Fremont County. That hearing is also chronologically the most recent major event garnering such coverage in either case. The court will reiterate its position relating to the ability to conduct the trial in Fremont County. Absent the concerns of locating a fair and impartial jury, the court has total and unequivocal confidence the trial in Fremont County would pose no concern. This court presides over all felony cases and all district court civil cases in Fremont County. The court has conducted many trials in Fremont County. Never has this court found Fremont County jurors to be unable to honorably serve and faithfully discharge their directives to follow the law and instructions of the court to uphold a defendant's right to a jury trial with a fair and unbiased jury. In addition, any concerns raised over courthouse security or ongoing construction of the adjoining jail facility are without merit. The Fremont County Sheriff's Office is fully capable and competent to oversee a trial of this magnitude. The office has always provided exemplary security for the court, whether at routine criminal hearing days or during heavily attended and emotionally charged hearings such as Lori Vallow's sentencing hearing, where heightened security risks are present. Further, that office provided personal security for the court beyond expectation during the entire course of the first trial in Ada County. Regarding the physical facilities, the Fremont County Courthouse is notably beautiful and historic facility. The clerks are dedicated, experienced, and responsive. To summarize, absent the concern about selecting an impartial jury, not tainted by pretrial publicity, Fremont County would unquestionably be an ideal venue for the upcoming trial. Nevertheless, the objective considerations of the sheer population differences between Fremont County and Ada County cannot be ignored. As demonstrated in the companion case, a large number of prospective jurors will be necessary to summon, qualify, and question through the use of a questionnaire and both group and individual voir dire in order to ensure that the balance tips in the favor of robust due process to Daybell, particularly in light of the potential for capital punishment. The state has presented no evidence to ameliorate any concern that the pervasive media coverage has not inundated Fremont County jurors with pretrial exposure in Daybell's case, and actual exposure to the presentation of the evidence at trial in Vallow Daybell's case, of which the proffer to the court is that there will be significant overlap in witness testimony and other evidence. In addition, ironically, the sheer expense of litigating the case and the companion case has impacted Fremont County financially. That financial impact becomes another source of potential jury taint, that hard-working citizens of the county are likely frustrated, and that the prospect of paying for these cases resulting in further interest in following these cases, even those citizens are less interested in the subject of the case. The court has carefully considered the unfortunate reality that there will be additional expense in, again, moving this second trial to Ada County. Finally, the court must consider the empirical evidence that it does have before it, that Ada County, the most populous county in Idaho, has the resources from a jury selection standpoint to impanel an impartial jury and is willing to provide the facility to conduct the trial. The reality is, and the state would likely concede, that nearly every reasonable, eligible working citizen of Fremont County capable of jury service has followed the Chad Daybell and Lori Vallow story. The discovery of JJ and Tylee Ryan's buried bodies on Chad Daybell's Fremont County property sent shockwaves through the community and propelled the case into the national spotlight. While the expense of conducting trial in Boise is immense, it is less expensive than attempting and failing to seat a jury at Fremont County, only to thereafter return to Ada County. Unfortunately, the court finds that scenario to be a distinct possibility. Finally, the state requests to consider alternative locations closer in proximity are not unreasonable. However, the extensive preparation and time involved administratively has been expended to preparing for trial in Ada County. At this time, with only a few months before trial begins, it would be impracticable, if not impossible, to pivot to an alternative county and begin anew the complex machinations of administering a case that this magnitude and complexity. The logistics of hosting this trial, including the sheer length of the trial, place a burden on the hosting county. Taking over a main courtroom for months creates issues requiring extensive planning and preparation. Additionally, and again on the consideration of cost, the court will note that Ada County made significant concessions that lessened the fiscal impact on Fremont County relating to the trial costs. It is unlikely that other counties would be willing or able to extend such concessions, especially on short notice. Thus, the court is not convinced that it would be any less expensive to host a trial in an alternative county. The court recognizes the sacrifices that are required given the difficult situation. For local prosecutors, there is a burden of having to relocate away from family and community for an extended time. The burden extends to others, including witnesses, victims, families, and law enforcement involving the security staff. The court decision to allowing the live streaming of the trial will serve to lessen that burden to some extent. Notwithstanding, the court remains convinced that the proper venue for trial remains Ada County, and that a fair and impartial jury will take place there, as was accomplished in the companion case earlier this year. Therefore, the state's renewed motion to reconsider change of venue is denied. Now, the significance of that, is the court notes, is we've always talked about. It's always about the money. And in this particular case, that's what it's really about. The prosecutors want to do it close to home because it's expensive to pack up and go do a trial on the other side of the state. Trust me, I've done that. It is expensive. You got to come up with lodging, food for not only you, but your staff that's coming with you to trials, staff, etc. So that's what it really boils down to. And the judge also noted that the prosecution failed to present any empirical data, which would say that basically people in Fremont County are not aware of this situation at all. They didn't conduct that research because they know that it would be not accurate, would not come out in their favor. So therefore, that is why they are doing that the way they're doing it. They have no data. And the court said, you didn't present me with any new data. Therefore, we're going to do this in Ada County. It makes sense. The next order was the defendant's motion limited to limit the state to consistent argument on defendant's relative culpability. As you may recall, in the trial of Lori Vallow, the prosecutors stated that Lori Vallow was the mastermind, the manipulator throughout the trial, and that everything was done at her request. The killing of her children, the killing of Tammy Daybell, everything was done at her request. Well, obviously the defense, in this case, Chad Daybell, likes that idea. That's what I said early on in this case. You have to say that he was manipulated by this woman, what have you, but he didn't know the extent of what she and her brother, Alex Cox, were in fact doing. So the defense files a motion and say, hey, Judge, we just want to make sure it's clear that the prosecution should have to maintain the same theory of prosecution and say that Lori Vallow was the leader, the mastermind behind everything that took place here as it relates to the death of Tylee, JJ, as well as Tammy Daybell. And the court denies it based upon the record that was created. And the defense can revisit the issue if something arises at trial. Now, for an attorney to go in and argue, let's say on day one, that a particular position should go forward and then go do it in a different case, like not related, that's okay. I have a bit of a problem. I mean, the prosecution's duty is to achieve justice. That's in the ethical standards for prosecutors, not to obtain convictions. And it's a little disingenuous when you do one trial saying that Lori Vallow was the manipulator, the mastermind, the leader, and then they're going to flip to this trial and say Chad Daybell was the manipulator, the mastermind, the leader of everything that took place. You have to admit it's a little disingenuous, but the court's going to allow the prosecutor to do that to a certain extent. We'll see if the issue comes up. Like I said, is it going to be a huge appellate issue? No. The prosecution has their theory of prosecution that they want to go forward on, and so be it. But I just think it's interesting, the inconsistencies that are taking place there by the prosecution. And then finally, the court issued an amended notice of pretrial setting. Obviously, we have a trial starting on April 1st, 2024. Oh, yeah, and Lori Vallow has her trial in Arizona beginning on April 4th, 2024. It's going to be interesting, particularly if they actually both go at the same time. Pretty sure Chad Daybell will go on schedule this time. There's no more need for continuances any further in this case. The one in Arizona, Lori Vallow will probably get a continuance in that, but it's probably her only shot is to demand her right to a speedy trial. So there you go. There's the latest news as it relates to Chad Daybell. They're going to stay in Ada County. Now, we flew up there. We jumped in CrimeTalk 1 last time and went and checked out the trial of Lori Vallow. I'm assuming we'll do the same. We'll just have to wait and see. I think the judge made the right decision. Small community, everyone's going to know everybody, and just do it right. Just take the larger jury pool and try to get 12 people that know little to nothing about the case, so that it is a fair trial. And then if Chad Daybell is convicted, and if they go forward on the death penalty, so be it. And one of the things in the pretrial order is that all discovery, which remember is the reason why Lori Vallow had the death penalty taken off, because the prosecution had not turned over all discovery. And in this particular case, all discovery needs to be turned over no later than 5 p.m. on February 1st. If you don't turn it over by that date, guess what? You don't get to use it. All right, the Indiana Supreme Court announced that it will listen to oral arguments next month in the latest development in the Delphi double murder case against Richard Allen. Now, the oral arguments are set to commence at 11 a.m. on January 18th, as the state's highest court will hear Allen's request to reinstate his original defense team of Bradley, Rossi, and Andrew Baldwin, and remove the specially assigned judge, Judge Fran C. Gull, from the trial. Now, the petition also wants the judge to schedule a trial within 70 days of its ruling. Now, the lawyers were removed from the case in October by Judge Gull following a leak of online crime scene evidence, with the judge referring to the attorneys as grossly negligent as part of her reasoning behind the attorney's removal. The judge also said the removal of the attorneys would benefit Mr. Allen because he would have access to a competent defense team. Now, the leak was attributable to a former co-worker of Baldwin's who reportedly took photographs of the crime scene images, which had been left out in a conference room in his office. Now, according to various reports, Judge Gull and the Attorney General Todd Rokita contend that the petition should be rejected since the defense did not utilize the appropriate legal avenues, i.e. the appellate process, and instead of just filing this extraordinary writ of mandamus, that's what they should have done. Well, the attorneys argued that filing a writ was an appropriate legal avenue since it represented the only way to have Baldwin and Rossi reinstated to the case in time to hold Allen's trial within 70 days of the filing of the writ. Now, Baldwin and Rossi assert that a writ was the only way to try and expedite the trial, which was initially set to be held in January, and that appellate process could take years. Now, the lawyers argue that an appeal, and the reason why it would take years is because you would have to go to trial first, lose, and then address all those issues, not only in the appellate process, as well as any post-conviction relief process. So let's get the issue resolved now. So the writ also includes the attorney's response to the evidence leak, with them stating that the leak did not disrupt their strategy one iota. And the Indiana Supreme Court has turned down a plea submitted by Allen to open additional records connected to the case and make them public. Now, Allen is charged with 2 counts of murder in regards to the February 2017 deaths of Abby Williams and Libby German near the Monard High Bridge in Delphi. Currently, Allen's trial is scheduled to take place in October of 2024 as his new attorneys are getting up to speed.
As a pet owner, you want to give your furry friend the very best. That's why Baked in Colorado's CBD-infused dog treats are the perfect choice. These delicious treats not only taste great, but they also provide a wide range of health benefits for your pet. CBD has been shown to have many positive effects on dogs, including reducing anxiety, alleviating pain and inflammation, and improving overall wellness. Baked in Colorado's treats are infused with premium, full-spectrum CBD oil, meaning your pet will benefit from the whole plant extract. Not only that, but Baked in Colorado's treats are made with all-natural human-grade ingredients, so you can feel good about what you're giving your pet. They're also free from wheat, corn, and soy, making them a great option for dogs with food sensitivities. Baked in Colorado CBD-infused dog treats are the perfect way to support your pet's health and well-being. With various flavors, including peanut butter, pumpkin, and bacon, your dog will love them too. So why wait? Head to www.bakedincolorado.com today and order your dog a bag of these delicious and nutritious treats. Your pet will thank you for it.
Now, I've told you many times throughout the podcast that guns complicate everything, okay? And I am a gun advocate, a firm believer in the Second Amendment. But as I tell my clients all the time, they complicate everything. Let me give you an example. So a woman who chased down and killed a 62-year-old man who was accused of committing a minor traffic accident by running a red light claims that she never intended to shoot him, only to take down his license plate number for the 911 dispatch caller. Now, however, witnesses told a different story at the trial of Hannah Payne, telling jurors that the woman cut off Kenneth Herring with her car, jumped out and punched him after the May 7th, 2019 collision. Then, witnesses said she brandished her hip-holstered firearm, threatened to shoot Herring twice, and immediately did so. Well, Tuesday, Payne was convicted of felony murder, malice murder, aggravated assault, false imprisonment, and weapons possession charges in a Clayton County, Georgia courtroom. Now, the jury took about 2 hours to render its verdict, not a long time. The evidence was pretty overwhelming. Now, she obviously looked sad and sobbed when the verdict was read, but that's what happens when you do things that you shouldn't be doing. So both Payne and the witnesses agreed that she drew her gun, but during her testimony, she claimed that she never intended to fire. Instead, she claimed that Herring shot himself in the struggle for the firearm. Now, Payne's car was not involved in the crash at this deadly altercation, but she pulled over to dial 911 after witnessing Herring run a red light in his Dodge Dakota pickup that caused a minor traffic accident with a semi-trailer. Now, Herring waited at the scene of the crash for about 15 to 20 minutes before ultimately driving away. She ultimately followed and pursued the victim in this particular case, who it was believed was having a medical episode and ultimately passed away. The jury did not believe her testimony. But the point is, ladies and gentlemen, I get it. You want to have a firearm for safety, you can do that in most states. If you're not a prohibited person, you can do that. But you have to actually be in fear of death or serious bodily injury before you can use it and be justified under the law. The best advice is when the dispatcher tells you, don't do anything, just get the license plate number, don't approach anybody. That's what you do, because these type of situations can escalate, and the bottom line is, well, then it gets really complicated. Complicated like you could spend the rest of your life in prison. I want to talk about some of the comments as it relates to the Gabby Petito case from the story that we talked about yesterday. So as you know, Gabby Petito's parents are suing Brian Laundrie's parents for intentional infliction of emotional distress, alleging that the statement that they put out that they hope Gabby returns home was false and they knew it, and therefore it was with the intent to cause them pain and anguish. All right. I personally think the lawsuit should not have been filed, but in our American legal system, you can sue anyone for anything, and the legal standard is such that if you make out the elements of the offense, in a civil case, the elements of the alleged tort, then the case goes forward, and then discovery needs to go forward, and you can see if you have enough to make the case. Well, the attorneys for the Petitos wanted to have the attorney that was retained by the Laundrie family for their son to discuss what he discussed. Now, that is offensive, and any attorney should have known that would be a breach of the attorney-client privilege. That would be like the Laundrie family coming back and saying, you know, we're going to sue you for intentional infliction of emotional distress because you filed this lawsuit knowing that it was frivolous. And by the way, we want to know what you and your attorneys talked about during your conversations. Did you think, hey, maybe this case is a little weak, but maybe we can get enough to go forward on it? We could lose. How about that? When you talk about the strengths and weaknesses of your case, should that come under the breach of the attorney-client privilege because maybe you sued somebody? No, of course not. That would be ridiculous. Anyway, the Petito's lawyer withdrew the motion to compel the attorney to actually testify. It was the right thing to do. I don't think a court would have allowed it. But I think it goes to show you that there isn't enough there. But hey, a jury may decide and disagree with my analysis. So a lot of questions came in yesterday about this, and I understand that it is an emotional subject. And yes, if that was my daughter, I would want justice, but you're not going to get it. I've always said, if you want justice, you're not going to go get it in a courtroom. You really are not. All right. So this is from one of our viewers' questions, and it kind of summarizes a lot of the questions that we received. Scott, well, you're right. No amount of money will bring Gabby back. I have to tell you, however, that the Petitos have every right to sue these horrifying people. We all know they knew Gabby was either dead or in a grave danger, yet did nothing to alert authorities of what their own son had divulged to them. I love you, Scott, but you're wrong. And then the follow-up question is, Scott, So could you explain the difference of the legal ramifications of a friend or a relative who has knowledge that someone has either been unalived or gravely hurt someone versus what the laundries participated in? Much appreciated. Yes, oftentimes we talk about what is the difference between morally the thing to do and legally the thing to do. Okay? So let me give you an example. A family member, let's say a son, goes to his parents and says, I've done something terrible. I'm a horrible person. The girlfriend is never coming home. And that's it. The parents don't do anything. What obligation do they have to go to the police? Under the law, zero, none, zip, nada. No one could compel them to go do that. There is a federal crime of misprison of a felony, but that's it. Now, if the parents engage in some conduct that says, okay, I know that a crime has been committed, let me help you escape, then they could be charged with accessory after the fact in aiding and abetting them. If they go and move evidence, move a body, once again, accessory after the fact. Maybe charges with tampering with evidence, something along those lines. But once again, they don't have a duty to go to the police, at least not legally. Morally, you may think so, but under the law, you don't. So I get it. You would think people would do the morally right thing to do, but most people don't. And remember, you may not like it, but the reality of it is that what morally you should do versus legally what you should do are two separate concepts, and the morally thing to do will probably get you charged or your family member charged versus the legality thing to do, which is keep your mouth shut. Now, perhaps should the Petitos not put out any statement? Sure. They said they felt pressure to put out a statement. They say they did not know specifically what was taking place. They didn't know the specifics. I get it. You may not believe them, but that's the evidence thus far. So I'm not sure how the plaintiffs in this case, the Petito family, is going to withstand a motion for summary judgment when the evidence is we didn't know. It's not what, remember, it doesn't matter what you think. It doesn't matter what you believe. It only matters what you can prove. All right. So I hope that explains it a little better. Maybe I didn't articulate it very well the other day, but hopefully that helps. Next, mercy killing or attempted murder. So Dwayne McCullough was charged this Wednesday with attempted murder after allegedly trying to choke his wife, Andrea Lee McCullough, while she was in hospice back in 2020, according to the arrest affidavit. Now, according to the arrest affidavit, witnesses claimed that Dwayne choked the victim in an attempt to kill her to ease her suffering while they were with her during her terminal cancer at a hospice care center. Well, the police did what they were supposed to do. They spoke with Mr. Dwayne, who said he admitted to placing his hands over the victim's neck, his wife's neck, in an attempt to ease her suffering. He also allegedly said that his actions were stopped by her family members that were present at the time, who pulled him off and admitted that he would do this again because he loved his wife. Now, his wife died from terminal breast cancer the day after the alleged incident, which occurred on December 21st, 2021. The warrant issued for Dwayne's arrest, though it's unknown why the warrant charges issued 2 years later after her death. Now, if convicted, he faces up to life in prison. Now, in a GoFundMe post created by the victim's son, her son wrote that his mom had been diagnosed with invasive ductal carcinoma breast cancer. And after entering remission, the cancer returned, becoming metastatic breast cancer, which spread to her brain, lungs, neck, and liver. The post notes that the affected part of her neck made it difficult for her to fully use her right hand and arm to complete daily tasks. And then on December 14th of 2021, her son said she had radiation in October and 3,600 milligrams of chemotherapy daily for 2 weeks with 1 week off. The son also noted that by then she had radiation burns that caused open sores and blisters in her throat, making it impossible to eat anything other than a shake. So let me know, ladies and gentlemen. Now, I get it. You can't go around killing people that are alive, even if they're in hospice care. And if anyone's ever seen anybody in hospice care, it is one of the worst things you will ever see. And you simply want to make the pain and the suffering stop. It's a little odd, though. I'm curious to see. We're going to follow this story because I want to know why it took 2 years. If this was such a horrible crime, why did it take 2 years? Let me know your thoughts. Mercy killing or attempted murder?